Good morning and welcome to Appeals.
Morning, Your Honors.
We appreciate your participation in this oral argument via Zoom. All of you are experienced practitioners, and I just want to take a moment and remind you that we are utilizing the same rules and procedures as if we were all standing in the courtroom today. So please keep that in mind. Plaintiff has, appellant has the opportunity to request rebuttal time, may reserve up to 5 minutes of rebuttal time if he's previously requested that from Mr. Hibner. Appellee has no rebuttal time. Each side will get 15 minutes to make its oral argument. And if there are any things, if we do experience a technological problem, I can't say that today, I don't know why, then just please bear with us. We'll get it fixed. We got a lot of smart people working on this. I'm not one of them, but we do have those folks out there who can make everything work. Before we get started, I want to introduce today's panel to you. Judge Arnold Goldman from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we call the case?
No, Your Honor.
You may call the case now.
Lisa Boyd versus David Benjamin Gibson IV, MD, et al.
We will hear from the appellant.
Good morning, Your Honors. My name is William Bruce. I'm here on behalf of the appellant, Lisa Boyd. Your Honor, this case being a review of grant of summary judgment, this is de novo review with no presumption of correctness. And I think that it is heightened somewhat given that this is a case where the trial court made a determination that our case law clearly states is generally the province of the jury, and that is whether or not the discovery rule applies and what date applies to the discovery of the alleged injury. As the court is no doubt aware, this is a lawsuit regarding a question of cancer treatment. Whether or not it's colon cancer or rectal cancer is one of the questions that appellant believes is a factual question in the underlying case. But what's here before the court is whether or not Lisa Boyd should be, whether or not the appropriate question is, was Lisa Boyd aware that radiation was a post-surgery treatment for cancer, as opposed to just whether a general recognition of radiation being an available treatment for cancer is enough to put her on notice that the failure to give radiation post-surgery may have been a departure. We believe that the relevant inquiry, given the information and knowledge that Lisa Boyd had at the time, that the appropriate question is whether or not radiation was a post-surgery treatment. We look at the factual history of this case.
Mr. Brook, let me ask you a question, because this case is a little confusing to me, and I'm trying to understand exactly what we are talking about. It appears that we've got two periods of time here. We've got Dr. Gibson, who performed the surgery, the rectal surgery, and removed the tumor. And originally, in your complaint in the informed consent section, it went to the treatment that he rendered during 2014, and then you filed this amended complaint, which basically is the same. Everything in there is the same other than the date, which then extends it to September 26 of 2016. As I understand it, Judge Smith ruled that all of these activities that occurred as a result of the initial surgery, which would have included the informed consent that was given prior to the rectal surgery, and any treatment that occurred during that time, that the statute of repose was applicable. So all of those activities including the initial informed consent, would have been out unless there's some unless you can prove fraudulent concealment. This amended complaint seems to be trying to take this to subsequent treatment. And I guess the question I have that I'm trying to understand is the only additional apparently the real treatment that was performed by, because I guess what's confusing to me is how informed consent is being used here. Dr. Gibson also put in the portacath, and according to his notes, and I'm looking at these notes because the judge indicated that she reviewed the records in the case, and there's a part of the record, said that the portacath was put in, and he apparently, according to the record, gave informed consent with regard to the portacath. This other treatment other visits that she had with him, and obviously we all call this treatment, but those were basically follow-ups from the original treatment that he rendered, which was the original surgery. All of the notes reflect that was the original treatment, that he had referred her to the medical oncologist for treatment for chemotherapy or whatever. I'm trying to understand how this informed consent even applies to any of this subsequent treatment. Under what circumstances would you expect a surgeon to give a second informed consent? It's almost like you expect them to give this informed consent every time they have a return visit for follow-up, I guess is what I'm getting at, because that's the only reason I can see why you would have extended this date in the amended complaint to try to get it under the statute of repose. And otherwise, I don't understand it.
Well, Your Honor, the informed consent goes back, the argument for it is premised on the initial treatment. In other words, when Dr. Gibson first met and conferred with Lisa Boyd, he did not discuss many things with her. He didn't explain or describe a total mesorectal excision, more extensive surgery onto the lymph nodes. He didn't explain he didn't talk about radiation as a post-surgery treatment ever. The other dates, the mention of the subsequent treatment, are
all those things that you just discussed, are you saying that all of those things he didn't discuss are still actionable, or if they come within the statute of repose?
If he had a duty to disclose this, Patrick Wolf filed an affidavit saying the doctor has the duty to make these disclosures. The doctor did not make the disclosures. That brings it within the gambit of fraudulent concealment for purposes of statute of repose. In other words, we have to meet both the statute of limitations and statute of repose. She did not discover until Dr. Walsh said, you're going to need radiation. She didn't discover, no one ever mentioned post-surgery radiation as a treatment until Dr. Walsh did. That's something that informed consent required Dr. Gibson to have told her.
Well, explain to me why, if he didn't, let's say he didn't mention these things, why is, I understand that maybe he didn't give complete informed consent. I'm just saying for purposes of our discussion here, where does fraudulent concealment come in there? How do you meet the requirements for fraudulent concealment by his failure to give informed consent?
On informed consent, one of the bases one can successfully maintain an action on informed consent. Pardon me, let me get back up here to here we go. One, this is from both our Court of Appeals and our Supreme Court, that the defendant affirmatively concealed the plaintiff's injury or the identity of the wrongdoer, or failed to disclose material facts regarding the injury or wrongdoer despite a duty to do so. We have an affidavit from Patrick Wolf, MD, explaining that informed consent a good, complete informed consent is a duty that the physician has, the surgeon has, to his patient. So a failure to disclose this, and we've created a jury issue on this with the affidavit of Patrick Wolf. He failed in a duty to disclose a material fact. Radiation is a post-surgery treatment. He did not disclose that to Lisa Boyd. That's a material fact. Number two, plaintiff could not have discovered the injury. Plaintiff has absolutely no medical training and no reason to have questioned the surgeon when her treatment had been going exactly as the surgeon said. Going to give you an MRI. If the MRI shows lymph node involvement, then you would need chemotherapy. No mention of radiation. She's told initially, MRI, if no invasion of the tumor around the rectum or lymph node involved, then surgery is the best option as opposed to chemotherapy and radiation. She gets the CT. The CT doesn't show lymph node involvement. She's told surgery. It's exactly what they said she was going to get. She doesn't find out about lymph node involvement until later. She gets chemotherapy, which is exactly what they said. She didn't get radiation, which was never presented to her as a post-surgery treatment option until Dr. Walsh mentioned it. We're not saying Dr. Walsh did any, that was appropriate to have done. We're saying that the fact that it wasn't mentioned until Dr. Walsh did, that's the date that the statute of limitations is triggered. We're also saying that because she was not given informed consent, because chemotherapy was required, there was a duty to have told her about that potential treatment as a post-surgical treatment, and that never was done, that is what constitutes the fraudulent concealment.
So you're saying the fraudulent concealment goes back to the original informed consent prior to the surgery? Is that what you're saying?
It goes back certainly to the discussion of the fact that it wasn't revealed as a post-surgical treatment in the first discussions, and then because it wasn't discussed in the post-surgery visits. The fact that the doctor didn't say we should be doing radiation, that radiation is something that is a post-surgical treatment. Again, never brought up. The real question is someone with no medical training. I'm sorry, Your Honor, were you wanting to ask a question?
I was just going to say, are you saying that there's an occasion on at the time of each return follow-up visit that the doctor has a duty to give informed consent? Is that
at least one time, not at each one, at least one time? If he had said it at the first one or even the second one, and she had gotten the radiation treatment, more probably than not, the cancer would not have recurred. He didn't do that. He had a duty to have informed her of it as a post-surgery treatment and did not. And I see that my time is expiring in 1 second.
I thank you, Mr. Grote.
Thank you, Judge.
All right, we will hear from the appellee.
May it please the court, I'm Maggie Roney and I represent Dr. Benjamin Gibson and his group, Memphis Surgery Associates, in this matter. The trial court correctly granted Dr. Gibson and MSA's motion for summary judgment on the basis that all of the claims advanced by the plaintiff in this case, both in the original complaint and the amended complaint, are time barred. The original complaint alleged that Dr. Gibson negligently performed a surgery on Ms. Boyd for her rectosigmoid colon cancer on September 16th of 2014. That original complaint also made claims of informed consent, improper informed consent, related to the 2 pre-surgery visits that Dr. Gibson had with the plaintiff, and those occurred in August of 2014. The statute of repose in Tennessee is 3 years for medical negligence actions. The statute of repose is an almost absolute bar to recovery. The discovery rule analysis that Mr. Bruce has been advancing is irrelevant to a statute of repose argument. While it may be relevant to a statute of limitations argument, any claim beyond 3 years prior to the date that notice was sent by the plaintiff it is therefore barred by the 3-year statute of repose.
What is your response to the fact that he says that this is fraudulent concealment?
So, Your Honor, there are 4 elements to fraudulent concealment, and a plaintiff, taking a step back, when a defendant establishes a statute of limitations or statute of repose affirmative defense, which we have done here by setting forth the dates on which the alleged negligence occurred and then establishing that notice was sent more than 1 year or more than 3 years after those dates. At that time, the burden then switches to the plaintiff to point to specific facts which show that the case is not barred by the statute of repose or statute of limitations. And in this case, the plaintiff is traveling under a fraudulent concealment theory as to both the statute of limitations and the statute of repose. And there are 4 specific elements to a fraudulent concealment argument, and the plaintiff has to prove all 4 or meet her burden of production as to all 4. And if her proof is lacking as to any of the 4 elements, then the fraudulent concealment argument fails. Those 4 elements are that the defendant failed to disclose material facts regarding the injury despite a duty to do so, that she could not have discovered the injury or wrongdoer in the exercise of reasonable care and diligence. Number 3, the defendants knew about the facts giving rise to Ms. Boyd's cause of action. And then 4, that the defendant concealed material information by withholding information or resorting to trickery. Taking those one by one and I'll start with the 3rd and 4th elements because the plaintiff's brief addresses those 2 elements with 1 paragraph with no citations to the record and no citations to any specific fact. And as the case law provides, the burden is on the plaintiff to point to specific facts to support each of those allegations, and they fail to do that here. A paragraph of conclusory statements by counsel does not meet this burden. Now, starting with the 3rd element, which is that Dr. Gibson knew Ms. Boyd had been injured and that he was the one who injured her. The plaintiff attempts to establish this element by saying, well, without any citations to the record or pointing to any facts, says, well, Dr. Gibson knew he was the one who did the surgery and he knew he did surgery incorrectly and he knew he didn't recommend radiation therapy for Ms. Boyd. But the most significant flaw in this argument on the merits is that Dr. Gibson, it's undisputed that Dr. Gibson used the plaintiff's pathology report to then determine what her post-surgical course of treatment would be. And their argument assumes that at the same time he's reviewing the pathology report and determining what treatment to recommend, rather than recommending the treatment he knew was the proper treatment, instead he decided to not recommend it and conceal from her that he was not recommending it. And that's not a reasonable inference from the facts. And again, the plaintiffs don't point to any facts in the record to support that element of fraudulent concealment. So their argument fails then and there because they can't prove the 3rd element. Moving to the 4th element, which is that Dr. Gibson concealed material information from the plaintiff by withholding information or making use of some device to mislead the plaintiff in order to exclude suspicion or prevent inquiry. Again, they don't cite to any facts in the record to support this. And this is the same approach they took at the trial court level as well. But we have to keep in mind that the injury that we're dealing with here is the recurrence of Ms. Boyd's cancer, which occurred in 2017. So to meet this element, the plaintiffs have to establish, and their theory is that Dr. Gibson knew in 2014 that Ms. Boyd's cancer was going to recur. And he intentionally withheld information about post-surgical radiation from her in an effort to prevent her from asking about pre-surgical radiation, as I understand the argument, because he knew her cancer was going to recur. Again, that's not a reasonable inference. Having no knowledge of an injury in 2014, he had nothing to conceal.
Is it is it just the pre-surgery recommendation or advice regarding radiation, or is it post-surgery? Because we had this discussion. I was asking him about these extended dates and whatnot, and about these follow-up visits, and as to whether or not he had an obligation to offer her informed consent at these follow-up visits subsequent to the surgery. And counsel's statement was, he had to at least bring it up at least one time or whatever, and tell her about the offer of radiation or potential for radiation. What do you say to that?
So as I understand the plaintiff's argument, Your Honor, it's that Dr. Gibson fraudulently concealed radiation as a post-surgical option from her throughout the course of her treatment. So beyond surgery on those follow-up dates, and including the dates where she came in for her portacath placement that Your Honor referenced earlier. That's the argument as I understand it. And the analysis is the same because her cancer did not recur until 2017. So at all of those post-surgical appointments, he does not know that her surgery is going to recur, and he has no injury. There's no injury for him to conceal, for Dr. Gibson to conceal. And so if the argument is he's not giving her informed consent because he's hiding from her that he should have ordered radiation on some date prior to that, then it fails on the 4 elements of fraudulent concealment, again, in the same way that the pre-surgical informed consent claims fail.
I guess the problem I'm having is that it appears that what's being alleged is not that it wasn't offered, but that it was not raised as a possible treatment, whether it was being offered or not. Am I missing that?
Could you ask your question again, Your Honor?
I said it appears that what the plaintiff is saying is that whether it was actually offered as a treatment, she should have been told about it. That's what I'm understanding is being said here, and that she was never told about it until 2017 as being a potential treatment.
Yes, Your Honor. I think that is the argument. I think the argument is that she should have been given alternatives to the treatment that Dr. Gibson recommended, including the potential alternative for radiation. Now, before the surgery, Dr. Gibson did have a discussion with Ms. Boyd about what the various treatment options were, and Ms. Boyd has admitted that in her affidavit and in her deposition testimony. She admits that before the surgery, there was a discussion she had with Dr. Gibson where he said, we're going to do an MRI, and if we see lymph node involvement, then you may need neoadjuvant chemo or radiation. If not, we'll proceed with surgery. So she admits that at that time, radiation was raised to her. The plaintiffs are trying to draw a distinction between radiation recommended pre-surgery and radiation recommended, or not even recommended, but mentioned post-surgery. And it's really splitting hairs, Your Honor, because if we're looking at the issue of the discovery rule, well, she knows about radiation, and that's undisputed. She knows radiation is a treatment option for cancer. Whether she knows it's pre-surgery or post-surgery, that is too fine of a line to draw to then get the benefit of the discovery rule. And she
acknowledges in her deposition that he raised this non-adjuvant or whatever treatment, which would be chemotherapy and or radiation. She acknowledges that in her deposition.
She does, Your Honor, and she also does in her affidavit, which is found at volume 2, page 210 to 211. She says, and to give the court a little background, when the plaintiff initially raised her fraudulent concealment claim, she initially said the fraudulent concealment was that Dr. Gibson did not produce all the medical records to her. The problem with that claim is that the records were not requested until 3 years after the surgery, or more than 3 years. So that wouldn't get around the statute of repose. So the plaintiff then retooled her fraudulent concealment argument and said that what was concealed from her was the fact that she had cancerous lymph nodes, and nobody told her that. Well, then when we deposed her, she admitted that she was told right after her surgery in the hospital by one of Dr. Gibson's partners that she did have cancerous lymph nodes that were found during the surgery. So then the plaintiff pivoted again to the argument that's before the court now, which has to do with this post-surgery radiation. But the affidavit was filed when the plaintiff was still traveling under the lymph node theory. To give you some background for what I'm about to read. At volume 2, pages 210 to 211, in her affidavit, Ms. Boyd says, "That was the first time I learned that Dr. Gibson had concealed from me Dr. Jordan's findings of cancer in my lymph nodes and the tumor invaded the muscle. Had Dr. Gibson informed me of these findings and the need for radiation therapy when I visited him after the surgery, I would have had the radiation treatment and chemotherapy in September of 2014 and not delayed it until 2017. And she also admits in her affidavit that the pre-surgery discussion was, again, as I mentioned before, whether the MRI showed lymph node involvement, she may need radiation. If it doesn't show lymph node involvement, then she would not. So it's undisputed she was aware that radiation was a treatment option. Now,
let me ask you a question. I'm sorry to take you off your point there for a minute, but I have a question about the judge's ruling. Is the judge's ruling sufficient in light of this discussion? In other words, in terms of the application of the statute of repose and the statute of limitations, what applies to what? I'm having some difficulty with the ruling as to how to really, and maybe that's been part of the problem here. It seems to be based on this knowledge aspect of it, but it doesn't say, the statute of repose applies to this and pre-surgery or post-surgery or what she knew at the time and all these things we're talking about here. Is that a problem?
no, I don't think it is, Your Honor, because there are 4 elements to a fraudulent concealment analysis. And the plaintiff is traveling under a fraudulent concealment theory as to both the informed consent claims that fall under the statute of limitations, as well as the surgery and pre-surgery informed consent claims that fall under the statute of repose. The plaintiff's theory is the same. And one of the 4 elements of a fraudulent concealment analysis is whether or not the plaintiff could have discovered the injury in the exercise of reasonable care and diligence. And so I think Judge Smith, that was the element that Judge Smith found was not satisfied in the fraudulent concealment analysis. And so therefore it fails because all 4 of the elements must be satisfied. But she does, in her order, she does also address the fact that I think she said something to the effect of whether Dr. Gibson laced together post-surgery radiation as opposed to pre-surgery radiation and the surgery and the type of cancer she had, that does not rise to the level of fraudulent concealment. So I think she's addressing all of the elements as a whole, and then she specifically speaks to that knowledge element. And as long as the plaintiff, again, doesn't satisfy any of the elements, then the defendant's motion is properly granted. I would submit to the court that perhaps the even stronger argument for our position is that the plaintiff hasn't established elements 3 and 4 of the fraudulent concealment analysis, because if the court looks at their brief, they don't even cite any facts whatsoever to support those 2 elements. But also, we would submit that none of the 4 are satisfied, including the one that Judge Smith found was not satisfied, which has to do with discovery of the injury. And it looks like my time is about up. If the court has any other questions, I'm happy to answer them. Otherwise, I'll ask the court to please affirm the ruling of the trial court granting Dr. Gibson and MSA's motion for summary judgment. Thank you.
Thank you. We will hear from the appellant. You're muted, Mr. Bruce.
I just noticed that, Your Honors. In regarding the 3rd and 4th elements of fraudulent concealment and the brevity of the brief on those issues, I was attempting not to be prolix and not to be overly wordy. We clearly set out the factual basis for those by reciting to the hospital and more precisely, to the doctor's medical records, the fact that there was no mention of chemotherapy radiation therapy in any of the post-surgical visits. So to assert that yes, indeed, in the actual written page of the brief under the heading, there might not have been a cite to the record. But that's because the record had been so clearly established in the fact situation and in the prior discussions. We believe we established that the doctor had a duty to make a full and proper informed consent. We have that both through the pattern jury instruction and through the affidavit of Dr. Wolf. We go through the office visits showing he did not, at least as shown by the documents, he did not reveal this information. He concealed the information. So
what about your client's testimony that counsel referenced, that prior to the surgery and the discussion of the non-adjuvant treatment, he mentioned about the fact of radiation, potential radiation and chemotherapy?
We have always acknowledged she knew radiation was a pre-surgery treatment. She did not understand that it would be appropriate post-surgery or an option post-surgery. The doctors never told her that. They mentioned it as pre-surgery only, and I don't think that's too much of a hair or a distinction to make. And if anything, it's a distinction the jury, not the judge, should be resolving. If there's a question of should this be made, and it's a factual question, that's for the jury. The judge invaded the province of the jury.
Let me ask you one other question. After he did the surgery, I mean, these visits that I alluded to earlier, these were follow-up visits, but they also say that he referred her for medical treatment to Dr. Walsh. And Dr. Walsh was the medical oncologist. Is this the treatment that you're alluding to, this the chemotherapy and or radiation treatment? Isn't that treatment that would have been recommended by Dr. Walsh?
No, Dr. Gibson discussed it pre-surgery. He could have discussed it post-surgery. And in fact, when Dr. Walsh did recommend radiation, she got it right away. Suit was filed within a year of that time.
Well, how soon did Dr. Walsh see her after the surgery? Wasn't it either in September or October, right after the surgery?
The time that Dr. Walsh saw her after the surgery and said anything about radiation.
No, I'm not asking you that. I'm asking you when was her treatment? When was she referred to Dr. Walsh for treatment subsequent to the surgery?
Your Honor, I'm looking to refresh myself on that. I can't tell you the exact date of the first time she was seen by Dr. Walsh post to a treatment, post surgery. I do know the first time that Dr. Walsh mentioned
it was soon thereafter, was it not?
I believe so, but I also understand Dr. Walsh did not ever mention radiation either.
We're not talking about Dr. Walsh here. We're talking about Dr. Gibson.
I understand.
And let me ask you this. The reason Dr. Gibson installed the PAC, the portacath, that was back, I think, in September, and that treatment through the portacath was being administered by Dr. Walsh, wasn't it?
Correct.
All right, so we know that at least in September, which would have been within weeks after the surgery, she was under the care of Dr. Walsh. And is Dr. Walsh the doctor that would have recommended or for the treatment of chemotherapy and or radiation for her?
Either one.
All right, thank you.
Thank you, judges.
All right, thank you, counsel. We appreciate your argument. We will attempt to get you an opinion resolving this matter at the earliest possible time. Again, we appreciate you participating with us via Zoom. Ms. Tibner, anything we need to take up before we recess for the call to the next case?
No, Your Honor.
You may recess.
This honorable court is now in recess until 11 a.m.
Thank you, judges.
Thank you, folks.
Thank you.